Okay, howdy. Welcome to our Sunday at 9:05 a.m. Session, October 13th, 2019. Coming at you from Fort Worth. Looks like nearly everyone's here. I know that Fas will be joining us in a moment since he just emailed us. I was emailing with Joella this morning or last night. I don't even know. I was up quite late or early to this morning doing my FATCA preparation book, and she has her classes starting in an hour. So I told her that her group, which is Group D, can go first today so that she can bugger off to her class when it starts. Okay, so today's case study has the four groups. Group A is representing the taxpayer, Group B is representing State A, Group C, State B, and then finally Group D is representing State C, with PPP as our limited partnership, and yada, yada, yada. So now after class, I saw some questions from Susanna to us, or at least she sent an email referring to partnership scenarios published by the OECD back in, I think, 1999 was that report.
Yep.
Yeah.
So we can look at those afterwards.
Yeah.
And well, I don't see Fasu yet, but okay, he'll join while we're going. So for Group D,
Yeah.
Tatiana, Joella, and Praman, you're all there. Who is going to be presenting your countries?
Today I'm going to entertain you.
Great. Okay, so I'm going to put on my mute and open up my case study here on my screen. You can follow along. And okay, it's all set. And with that, we look forward to hearing the agents of country C's convincing arguments of why they should get everything.
Ladies and gentlemen, good evening, good morning, good afternoon. So we're the representatives of the competent authority of country C, a very unique country that likes to put provisions and put reservations into the model tax commentaries and doesn't agree with some things on some issues with the international tax community and try to protect its international tax base. So we would like to present you our submission on the following issue. So quick overview of the facts in front of us today. Our fellows from country A and country B. So as we all know, the issue in front of us today is a partnership, right? So the partnership that was established in country A in 2010, and it was established with two different partners. One of the partners was in country. One part of the partners was in country A, and other partners are located in country B. And would like to note that this partnership is fiscally transparent, both for your purpose in country A and country B. And one more thing we'd like to note is that the managing partner for the partnership is located in country B as well. Yep, it's where the place of management is. So how do we come into place here? So ultimately, we have a very good company in our state, which is called All Minerals. So All Minerals are a very attractive company, and the partnership is really quite liked it. So they decided to invest into its mineral rights and deposits and mining activities, and It acquired some shares, which it further resold and acquired their realized the capital gains in the amount of $18 million. Under our domestic law, we understand that the partnership is a legal entity, a separate legal entity in our country. And we think that the partnership has to pay capital gains on the income, on the tax, has to pay tax on the capital gains to us, right? But it hasn't been so. And the representatives of the taxpayer claimed that that on the basis of their double tax treaty between us and country C, it's not resident. It's not liable for tax under this double tax treaty. So we would like to explore the following three issues that are in front of us today. So first will be their tax residency of their partnership. The second one would be the income attribution, and the third one would be the double taxation relief, if any. So under tax residency, we would need to understand whether the partnership is a person, whether the partnership is resident in state or state B, and whether the partnership is liable to tax in state A and B. Further, under income attribution, we would need to understand whether partnership is an alienator of shares and whether it's taxable under domestic law of our state C, source state, which we already said that it is. And then finally to establish whether there will be any treaty relief provided. And if that's the case, to establish percentage of double tax relief provided by either state A or state B. So let's explore this in more detail, one issue at a time. So our findings conclude that under our domestic law, the partnership is a person. Moreover, we see it as a separate taxable legal entity, and under domestic law, it's liable to tax in our jurisdiction. Further, if we look into their model tax convention, where we put the reservations to some provisions and articles, we would like to say that according to their paragraph 6.3 to Article 1, there is an obligation of a source state to consider the liability to tax in state A. So we have to look into the state A, and we see that it's state A, it's not resident, the partnership is not resident. Then further, we'll look into their paragraph 8.8 to Article 4.1 into the commentary pre-2017, and which says that whereas state B treats partnership as fiscally transparent, partnership itself is not liable to tax and not considered as a resident of state B. As a result, honorable representatives of state A and state B, what we see that the partnership is not resident neither in state A and neither in state B. So, but it's it's not resident in either of your countries. Further, we would like to add that the derivative benefits to the partners are not covered through any specific clause in the existing treaty. So there is no provision in our double tax treaties that would provide any benefits to the partners. Then what's the most important point that we think is the partnership as a separate legal person precludes the view that income simply flows through the partners. Therefore, we just see the partnership as a legal entity that is not being resident neither in state A or state B. So this is our submission, that partnership is not a tax resident in either state B or state A. Further, we would like to walk it through with you with respect to income attribution, our reasoning on income attribution. We see that partnership is an alienator of shares of all minerals which is located in our state, and that capital gains arising from sales of shares are taxable in our state. We're aware of example 4 on the OECD PPT report where the tax partners would be liable, where tax partners would be able to benefit from the treaty, but we don't find it's binding in our case because it's not specifically included in Model Tax Convention, and it's not included in our treaty as well. Further, Article 13.4 on capital gains is not applicable as the alienator is not tax resident of any state. And Article 13.5, we think that we can exercise the right to tax capital gains with the accordance of our domestic law. Therefore, we think that we can exercise our right to tax under domestic law without any treaty benefits. Right. With respect to relief of double taxation, there is possibility to get the relief of double taxation, but there is a specific procedure. It's not applicable in our case, because we're the source state, and if there is an issue with the double taxation, that would be the procedure would be subject to initiation and alignment with the resident state, and therefore state A and state B have to decide it separately. So our conclusions and submissions would be the following. We believe that a partnership is taxable in state C under, in our state under our domestic law. We think with our findings show that partnership is fiscally transparent in state A and state B and not eligible for any treaty benefits. Then the OECD Model Tax Commentary 2017 derivative benefits for partners are not applicable in our case in the absence of their specific provision in the relevant tax treaties. And we reserve the right to exercise full taxing rights on capital gains where state A and state B would have to decide between themselves with respect to double taxation issues. Thank you for your attention. Please, questions.
So let's go in reverse order. And so that's good to start us off. That was really, actually, y'all were the right group to start us off. Then, so we would go to state B, which is group C. So in group C, who is representing as the agent of the country this week for the tax authority? Bill Seeger, turn on your mute then. Off your mute, I mean.
Yeah, that's me.
Okay, so you heard state C. It's all theirs, everything, 100%.
It's what I.
Nothing to attribute.
Doesn't surprise me coming from Tatiana. Hey, I'm a little green here. Do I hit the share button, Bill, and find the file?
Yes, use your share button and then select, well, you did it. That's perfect.
Okay.
Well, yeah, and then slideshow. Yep, and play from start.
Okay.
Excellent.
So I'm representing Group C on behalf of my two colleagues, Yannick and Nabil. Everything they provided to me was correct, so any errors are my own. Solve them from any tax interpretation errors. Tatiana gave a good summary of the facts. So I'll try and hit those that make the principled case in this instance for State B taxing the capital gain. What we'd like to emphasize, pardon me, what we'd like to emphasize is that we believe that PPP is actually resident in State B. And this is because of the existence of Tower Associates Management, the limited partnership, which is formed under the laws of State B. The affairs of Tower Associates, which is the general partner for PPP in State A, these affairs are managed by Tower Associates Management in State B. So the place of effective management in our view is in State B, not in State C or State A. We've got some bullet points with regard to that. The board of directors meet in State B. All strategic decisions are made in State B. Technical know-how is in State B. Nearly 80% of the investors, I'll say in PPP, are in State B. And any decisions relating to liabilities incurred by PPP are made in State B. So that's a fundamental difference between our view and the prior group, as we think the place of effective management is in State B. Oh, it's Nabil. Okay. As I said, we are confident of our position that the place of effective management is in State B. We have analyzed the location of the main income, the place of incorporation, the place and display of managerial power. All facts point to PPP actually being a resident of State B. Nabil, you can hit the next one.
Okay. Moment, just so I can be clear, you're choosing to treat the company, which company are you treating as corporation? PPP or Tower?
Well, you mean as a resident? I mean, neither is a corporation, are they?
No, but if we just go back to that other slide for a moment.
Yeah.
We're applying corporate residency determination. So when I see corporate residency and then I see PPP as a resident of State B based on place of effective management, are we treating PPP as a corporation for purposes of our dual residency test, or to establish initial residency before we apply any test, or is it an individual? I'll just leave that open. I'm not.
Yeah,
you don't have
leave
to
it
comment.
open.
I'm just leaving it as an open issue.
Leave it open. That's appropriate. Thank you. Since the place of effective management is in State B, the taxable gain will be taxable there. as I said, nearly 80% of the investors are in State B. So State B is quite interested in, getting its fair share of tax with regard to the all minerals transaction. Go ahead, Nabil. So in conclusion, we think PPP is a resident of State B. The all minerals sale occurred in 2013, I believe, which is after the 2008 treaty ratification. The treaty between jurisdictions B and C apply. And maybe even with A, because 21% of the shares are owned in A. So as an aside, I would go after those as well from a State B perspective. But in either case, relief from double taxation would be allowed for State A and State C. So thank you very much.
Okay. Before we move on to State A, I want to go back to you, Tatiana, and State C.
Right.
Do you all agree with the proposition this is to be examined under the corporate, or do y'all think it should be examined under a different standard? And there's only one other standard. that's individuals. So which of the two?
We respect the opinion of our fellow country B and understand their position. However, we would like to point that the facts that have been just presented, they relate to their residency of the partners, not the partnerships. And we refer to the PPP as a partnership that is resident, that is legally, that we see as a separate legal entity as per our domestic law. In the facts that you've presented, we understand that they relate to the partner, which is resident in State B, but this is not relevant to our case, to our position, due to reservation that we included into the model text commentary.
Okay, I'll ask my question again at the end though. I want to make sure that this residency concept, is it being applied under the default, which is, the first part of the article, individuals, or the second part, which is the corporate aspects of residency? And neither is the treaty's not applying the definition of residency for a country. Countries apply their own definition. The treaty's only tiebreaker mechanism. But regardless, okay, we'll move on, and I'll bring it up at the end. So that brings us to Group B, representing State A. And who's
that's me.
For Group B? Mark. Great. Okay. Mark Ray, agent of State A. And what claim y'all?
Okay, so let me go to share really quick. I mean, it's pretty simple. I mean, I'll go to share, but basically, let me go to share real quick. Share. How do I go to share? There we go. Not gonna go through the whole. There we go. Basically, and let's just get out of the way. So, I mean, sorry, this is not being right. Yeah, basically, I mean, we're looking at all of the states agree on this flow through, which effectively, because they're partnerships, because they're totally transparent, all of the income flows directly through the company directly to the partners, and thus effectively it should be treated as individual income and should be proportioned likewise, where State A would basically tax the partners located in State A, and State B would tax the partners located in State B, and it would split thusly. They wouldn't be necessarily treated as corporate in that sense. if that makes sense. But we base our argument on this flow through, the flow through of income to the partners and the transparency.
That's just what I was bringing up. It's just that, you know, which lens are you looking at? And y'all are looking at the, in support of your state, looking at the pass-through lens. Okay.
Right. So we're looking at the pass through, the flow through, and the transparency portion. I mean, basically, it's because they're partners. It's the partners should be treated as individuals in a sense. And thus, yeah, it's transparent. Everybody knows who everybody is. It's actually, and this is just coming up in a very weird. Yeah. So as domestic law under State A, they're transparent, and therefore they should be treated as such by State C as well. Via the treaty, right? Because both say if they're treated as transparent, they're treated as transparent. And the income is allocated to partners. So to me, the individuals or us, the individuals are treated as entitled to treaty rights. Make it going or.
So Tatiana, representing State C, y'all said fiscally transparent, but you said separate entity, right?
Yeah.
You're treating them as a separate entity as well.
Yeah, so now I'm sending you a question. Now, actually, we're looking at the residency from the state, from their corporate land, not individual. That's their issue.
But if it passes through.
Well, it passes through to you, but we don't accept this as a state. So as I mentioned before, we included reservation into the model tax commentary. We're one of the countries that included the reservation, and we don't believe that it can pass through unless there is a specific treaty, a provision in the treaty that addresses it. So, and hence there is no provision existence in our tax treaties. We don't see it as their pass-through entities.
Does the transparency not act as that provision?
Excuse me, Mark?
No, I'm just curious because we're talking about the transparency. Like if they're transparent, I mean, all of the states agree that if they're transparent entities, then they'd be treated as such, right? So if they're transparent, then you would gain the flow through. So wouldn't that be, would they then be treated as such? Wouldn't that act as that provision?
All the states but us. Sorry.
So A and B have this, but State C doesn't.
Exactly.
Which is why you're fighting against us.
It's not my personal, but like, yeah, it's a good decision. Sorry.
This is why us and State are the same, right?
It is yours. You're the agent for C. Get your money.
But both A and B have the same argument. We're like, no, we should split it.
No, but A and B have but to be clear, A and B, even if y'all have the same argument, you might have a different, just because you say, hey, part of it's mine, or this person or this entity is resident in my state, you still have the attribution. That got you the right to tax. Yeah. But what's the pool you're going to tax? And that's the attribution, right? So those are two totally separate. You can't get to the pool if you don't have a right to tax in the first place. The right being either because I'm claiming under the winner proposition, residency, or the loser proposition, source. Okay, anyway, I'll be quiet. I'm putting my mute on because we still have Group A representing our taxpayer, and we don't know what our taxpayer's position is yet. But
well, let's get to that now.
Okay.
So I cannot share while
I'm gonna try and stop.
Okay.
Somehow.
You're still there.
I'm trying to figure out how to stop it. Share.
I think it'll be at the top
Got it.
center of your
Got it.
screen.
Done.
Okay. All right, before I start, I just want to comment that I went through the OECD report, the 1999 report, which we're going to look at as a in class later after the presentation. And many of the OECD report recommendations, actually, the 1999 recommendations actually found its way into the 2000 MC. So with regards to partnership, so that's my little take on the 1999 report. We agree with state C insofar as they presented their facts. So we state, on behalf of the taxpayer, we would not review the tax. They're there. The facts, they're there in the slides. So facts in brief. On behalf of the taxpayer, we adopt state B position. State A and state B treats partnership under their domestic law in a similar manner. It's flow through. So we basically, as I said, adopt state B's position as so far as they've presented it. So the issue of residency, where whether it's in state A or B, for the taxpayer, it's a non-issue, because whether A and B doesn't matter. The issue is whether state C has the right to tax PPP, and on behalf of the taxpayer, our position basically is that state C has erred in imposing the capital gains tax on PPP. State C did not properly consider the income flows to the partners under the DTT as well as under the OECD MC 2000. And so we believe that's the issue. And so to guide us, we look at the commentaries of the OECD 2000, basically. We also look at the updated up to 2017, but we'll just, for purpose of arguments, we'll stick at this point to the 2000 MC, OECD's MC. And if you look at commentary, paragraph 5 to commentary 1, which I have in the screen, it clearly states that if it's a fiscally transparent situation, then the partnership application or under application to gain benefits under the convention or the treaties would be refused. However, it would go on to explain that where it's so refused, the flow through goes straight to the partners, and therefore the partners, they're eligible to the benefits of the convention. So whether they're in the taxpayer is in state A or B, this taxpayer is eligible to the benefits of the double taxation treaty as well as the OECD 2000 MC. Now, again, in support of our position, we looked at paragraph 5 of the commentary on Article 1, which I have up on the screen. And in essence, it went on to state that where the flow-through income is a transparent partnership to the partners who are liable to tax on that income in the state of the resident, then the income is appropriately viewed as paid to the partners since it is to them and not the partnership. Hence, the partners in these circumstances satisfy the condition imposed in several articles that the income concerned is paid to a resident in the other contracting state. And based on the commentaries, we can go on to look at the other screen, 6.5 commentary, paragraph 6.5 to commentary Article 1, and paragraph 6.6. All of those explanation essentially boils down to the issue that the commentary sort of narrow it to mean that even if the partnership cannot be taxed, which is contrary to what C is doing, it does not result in a situation where C would be able to tax the PPP as an entity under their domestic law. All of these articles, when read together, avoid that sort of situation and allows for the partners or ultimate partners in this case, because of the institutional investors, some of them their residence in state B because of the control of the partnership, etc. The commentaries to Article 1 and Article 4 clearly supports the taxpayer's position, irrespective of it, whether it's state A or B, that state C cannot tax the gains on the sale of shares of the company. So our position is that both state A and B can successfully proceed with the map, and state C would not be able to support its position, regardless of state C's position with regards to residency or their domestic law. It's simply not supported under the commentaries to Article 1 and Article 4. And so those are our submissions on behalf of the taxpayer. Any questions?
Dear taxpayer, we respect your position, but we also would like to remind you that you claim that you would like to not to be paid tax on the capital gains that you earned on our jurisdictions based on their applicability of the double tax treaty between our state and the state of your claimed residency, which is not the case, as we don't see any that you're resident in any of states, and therefore we don't think that this treaty is being applicable. And just to clarify that if the treaty is not applicable under our domestic law, we see that you're liable to tax in our jurisdiction. That's our position. Thank you.
Do you need a response to that?
No.
Oh, okay.
Okay, do any other states have anything else just to state in their claim over part of this money?
Yes, so on behalf of State B, the analysis that we did a little bit more in depth was looking at, we looked at Tower Associates Management, which is treated as a partnership in State B. And we figured that since Tower Associates Management is the company that's in charge of managing all of the activities of PPP, then for purposes of resident determinations, if they were to be applied to a partnership in the first place, even though they don't seem to, because PPP will be treated as a fiscally transparent company, and then all the income will flow through to the partners. But just for us to be able to have a more logical test and therefore more logical results coming from the test. We did a hypothetical scenario where we were treating PPP as a corporation, and if it was treated as a corporation, then where would the corporation have its place of residency, which we determined to be in state B. And then we brought the analysis further down the line, but under guidance of our state or our domestic tax laws, which is, since PPP or its agent in state B, which is Tower Associates Management, is treated as a partnership, then the residency issue would then, in our view, pass on from the hands of the legal entity to the hands of the individual partners, and this view goes along with paragraph 8.7 of the OECD commentary. And furthermore, to strengthen our position, we looked at the origin of the investment cost that was placed into All Minerals, which is a company in State C. And we were able to conclude that the activities that gave rise to whether it's PPP or Tower Associates Management, who are both considered for our test purposes to be residents in State B. The origins of that investment were linked to State B because all of the decisions, all of the liabilities, all of the operations that gave rise to the income for us to be able to take it as an investment into the company in State C are economically linked to State B. So since the investment cost is economically linked to State B, and the capital gain transaction is a one-time transaction, that does not constitute the trade or business of PPP or the trade or business of Tower Associates Management, we can conclude that the capital, it's only fair from an international jurisdiction resolution dispute standpoint for the capital gain to be taxed proportionally between State B, which is us, 78.5% of that capital gain should be taxed with us, and 21.5% should be taxed within State A. So, thank you.
Any other states want to stake out a claim? Well, we already have C and I think B, so that really leaves the taxpayer and
we agree with state B.
Okay. So that leaves Bruno and I as the arbitrator judges. My issue.
Yeah.
Go ahead,
I just wanted to make a point to the last remark about being a single transaction. Well, we didn't deal with this yet, so that's why probably we didn't touch upon that issue. But one of the issues sometimes that you have when you deal with the entity that is treated as transparent is the fact that, although of course is not a separate legal entity, it may give rise to a PE. So if you have an entity, which means that the argument of effectively connected trade or business that we or you use in the United States for the purposes of source or for the purpose of characterizing the existence of an ongoing activity, or the PE threshold for the purposes of tax treaty, it may exist. So many times what happens is that you have an entity which is disregarded for a disregarded entity, so fiscally transparent, but that entity may give rise to a PE for treaty purposes, case in which we have an issue of possible source taxation related with the fact that you have an activity there, even if it's the entity is fiscally transparent. So the fact that you have a one-off transaction, if it's related with the PE, can trigger source taxation. But okay, we will deal with that in I think two weeks probably. We will discuss that in more detail.
I have a quick question to that actually. Commentary says that the PE would be if one of the partners spends 12 months or more than 12 months in the source state. So how is it being counted? Like, do you have to be there for a consecutive period of 12 months or 12 months over like?
Yeah, in principle, there are several issues related with your question. One is that when you asked about, it's not necessarily the partner itself. Imagine that you have that entity. The partners can live in another country, but that entity is carrying an activity, although it's fiscally transparent.
Okay.
I mean, there is a good example, probably not the best for this example, but the typical case of an entity that is fiscally transparent is a law firm. A law firm in many countries is a partnership and is fiscally transparent. So the income is attributed directly to the partners.
Mm-hmm.
So, but if you have a law firm, you have an office and you're carrying activity. Let's assume that you and I, we are associates in the firm. The partners are living elsewhere. Where are you living now? In London?
Singapore.
Singapore. Let's assume we're both in Singapore and our partners are in London. It's actually very common. You have the magic circle firms that are UK based. So we are developing the activity. So we have an office rented. We're developing the activity. We assume that Singapore treats as fiscally transparent. So the income is going to be attributed to the partners, but probably they can tax something there because it's a sort of PE. It's treated as transparent, but I have a fixed place where I'm carrying the activity. I don't know if I'm making myself understand. So you and I, we are carrying the activity.
Yeah.
So it's a fixed place of business for the purposes of Article 5.
This is a double taxation exposure then? Because you'll be.
Yeah, potentially. Then we need to see how the state of the partners treats this. But in principle, the issue is going to be how Singapore is going to treat this, if they follow this this classification or not, and what's going to happen. But so there can be a PE. That's the first question. With partners located abroad. Actually, there's a very, very famous case. It's Linklater's case with India. So Linklater's was developing activity in India. So Linklater's, for the ones that don't know, it's a major UK firm, one of the best. And so they had a PE there. The issue if they could be taxed there or not. The partners, of course, the partners for the percentage of the income. The other issue is the time threshold. So for treaty purposes, the conventional threshold under the general rule of paragraph 1, the fixed place, is 6 months.
Mm-hmm.
So you have a special time threshold for construction PEs, which is the 12 months, which is Article 5, paragraph 3, under the OECD model.
Well, I think it was partnership. I was just control F partnership, just to see, like, researching about everything related to partnership. It was 12 months partnership.
It's possible if there's a treaty specifically dealing with that, so it may happen. Otherwise, you fall under the general rule and conventionally accept the 6 months, but you're going to see there are a whole bunch of exceptions. But in principle, in this case, it's going to be a 6 months in a 12-month period. That's typically how you're going to apply it. Otherwise, it's very easy to avoid it.
Okay, I have a question, and maybe our professor, who is the expert in US corporate tax, can probably help. In this scenario, the partners really, for state A's purpose, they're institutional investors. but those institutional investors themselves are partnership. So even if it's flow through, it's not flowing through to an individual, it's flowing through to another set layer of institutional partnerships whose residents are in state B. So under US law, for example, I'm assuming that partnership, that second tier and third tier, or whoever knows where it stops, because they're partnership, they cannot be taxed also. So in this case, what is state A's position? Because really state A, it's a bunch of partnerships that exist in state A.
Yeah.
State B
Yeah,
has a corporation. It's TAM.
So, I mean, I can let William to reply from the US perspective. My perspective would be as follows. Assuming that institutional investors are partnerships, which they don't need to be. I mean, it can be funds. And the fund, maybe it's is treated as a tax-exempt entity, but meets the condition as resident. But assuming your case, at some point in the chain, they will know who are the investors. I mean, in these types of investor, it's possible to. So if they know, and assuming that all the treaties involved have an identical provision, you will be able to claim, and all the jurisdictions in force have tax treaties in place with each other. You can claim between state A and the state where whatever the investors are resident. So if you're able to demonstrate that, you can apply the treaty. If the provisions don't match, or if you don't have treaties between state aid and whatever the investors are resident, then you cannot apply. So the biggest problem, I think it's, if I understood also the question is, where do we stop and how can we apply it? The only way is if all the treaties match in terms of the identical provisions, and all have the identical tax treaty provisions in place. Otherwise, it's not going to work. That's the fundamental challenge here. I don't know if it helped the answer.
Yeah,
So,
that does help.
From the United States perspective, and there's some interesting treaty theoretical issues here, and then there's rubber meets the road. The most basic, for me, step one of any analysis is it's not really the analysis itself, it's the evidence of the answer. And the evidence of the answer, so I write this in the materials, I've said this before, who will give you a piece of paper? Which country will give you a piece of paper?
Yeah.
Maybe all three. They will give you a piece of paper that says tax residency, and it is a piece of paper. So for the United States, by example, let's just say that you're a trust that is a pension, and that's possible, and the pension is qualified by our Department of Labor, and separately qualified by the Treasury Department. To be qualified by the Treasury Department is non-taxable, or not to have a tax-exempt entity, but still be taxably resident in the United States. Treasury will only do that if first you qualify for the Department of Labor pension regulations. Okay, so let's just say that you qualify for DOL, Department of Labor, and you go to Treasury, and Treasury says, great, you qualify. You pay a fee. I forget what it is, a couple $100, I recall. And it takes about 6 weeks, or it used to. I don't know if they're faster now. And you're mailed, not digital, you're mailed a physical piece of paper. It says you are a tax resident. I remember this because, by example, when universities have activities in foreign countries and they need to receive an exemption from withholding by applying the correct form in the foreign jurisdiction. So if it was inverse and it was the United States being applied to, if I'm a university, government entity, in this case, TAMU, I would but I was dealing with the US as if I was a foreign university, I would fill in a W-8 with my, on behalf of the payor, who is going to be the potential, or is the withholding agent. It's just whether they're going to potentially withhold or not. And they have full responsibility. So, I mean, before it was pretty lax and lots of mistakes. I would say about, well, we've researched this before, and there was anywhere from 30% to 80% mistakes. I mean, 80%. People just didn't know what they were doing. They didn't understand the tax law. Now it's all good because of FATCA. So people are very concerned the IRS audits it. So I submitted W-8, and on my W-8 versus a W-9 says, hey, I'm a US tax resident. My W-8 says, I'm not a tax resident. The other side says, oh, we have to withhold 30% because that's the US rule. But I check a box and I say, actually, I have a treaty benefit. The treaty benefit is I am a tax resident. I'm going to use article whatever. I put that in there. But now what do I need to prove up my treaty benefit? I need a tax residency certificate. That's the best thing. So I start with the very basic tax residency certificate. Now, I mean, technically that was always due, but in the past, almost never did the payor request a tax residency certificate. One of the few places I know that they did was India. In India, they had to have, not to have withholding, a tax residency certificate.
So wait. This is interesting for me. So the university will not ask me as a tax resident certificate?
So, no, that's a good point. No, that's
because
a good point.
Let me give it.
You filled in a W-8.
To prove what you said,
feel-
when I teach in Portugal, I only get the exemption from source taxation in Portugal when I submit my tax resident certificate from the Netherlands. Otherwise, they're going to charge me. So I don't know what's going to happen there, but
No. So right now, for the U.S. purpose, eventually this is going to be a fight, but it's not a fight this year. But eventually
Okay.
it's going to be U.S.
okay.
Where the service is being performed. Now, state of Texas doesn't have income tax, so it's not an issue for state of Texas. In California, California as a state requires withholding. It goes back to my saying last week from the movie, like shoot everybody and let God sort out the souls. California is withhold on everything and then let the people come back and request it. And so California payers are quite afraid. You don't have the state issue for Texas. However, at some point with online programs, I mean, where are the services performed? They're, from my perspective, clearly performed in Holland, Portugal. So one doesn't get to the issue, since it's not US source, we don't get to an issue of withholding.
Yeah.
However, after this digital report that we'll talk about next Sunday goes through, I can imagine a world where a new regulation is issued that says, oh, by the way, all those what you thought were foreign digital services are foreign services, but they were undertaken through digital means and had a US website. They're actually US source.
Yeah, so we need,
I can imagine this world. That world doesn't exist today, because if that world existed today, it weakens the US discussion.
So we need very strong arguments to reject the OECD approach, because I don't want to be taxed based on providing a digital service. So please, everyone, let's write very strong comments against this.
Yeah, indeed. So, but for my former universities and for, and there were different exemptions. So I've had 3 different exemptions I would apply for. 2 universities ago, the university was directly owned by the Catholic Church. There was no intermediary. They set up an intermediary
Yeah.
company later because of the lawsuits from all the child stuff. But at the time, they were the old-fashioned ecclesiastical structure. In fact, the church wasn't even incorporated. It was owned by the bishop on behalf of Rome. Now, that they needed a tax residency certificate to deal with other countries, and that became really weird. But there was, the IRS had this a way to issue a tax residency certificate to the Catholic Church on behalf of the bishop. Seriously. And then it got incorporated. It was on behalf of the church. Okay. But that was a tax exempt organization under the religious provision.
Yeah.
Not educational. Second, my last one was tax exempt organization under educational, but it still could receive a tax residency certificate, even though it wasn't subject to tax in the United States. It had a 0 rate. But okay, you'd say, well, that's cheating. But here's why. So in the US, tax exempt organizations are actually still subject to tax. They're just not subject to tax on the approved activities of the tax exempt activity. They're subject to tax on all other activities. We call that UBI, or unrelated business income, unrelated to the specific activities that the IRS has issued the exemption for. Okay, so I could get that here. Now, state of Texas, again, we're not an educational tax exemption. We're a government tax exemption. So I had the religious tax exemption, I've had the educational tax exemption, and the state of Texas tax certificate from the IRS is as a governmental agency, because we're a direct agency, an intra-agency of the state of Texas, not a university. And this is important for US law for other reasons. So I've had 3 different tax residency certificates. Now I take that certificate and I would file the equivalent of a W-8. Now you may not have realized it, Bruno, but you signed a W-8 when you did your, yeah.
You
Now,
you sign so many things.
The W-8 wasn't for state tax again, it was for federal withholding tax.
Okay.
If you had signed a W-9, I'm a US national, or I'm a US resident, then we might be obliged to withhold income, not withholding tax for services as a source. We'd be obliged to withhold income tax as if you were a regular US person earning salary, earning any income. Deal. So anyway, regardless, you didn't file that. So you filed a W-8 because you're not a US person. And that alerts, in theory, that alerts the payor governmental agency, Texas A&M in this case. And just to close the circle, it kicks in 2 different compliance regimes. And this is all software driven nowadays, but yet how poorly the software works. And it's not done by a tax or even compliance office. It's usually done by like the payor controller accounting people who don't know anything about tax. But the first regime is the most important regime, and it's not a tax regime per se, it's FATCA for our purpose, CRS for your purpose. But you don't have withholding connected to CRS, and we do have withholding, and it's 100% liability on FATCA. So FATCA, which we call Chapter 4 of our Internal Revenue Code, but doesn't matter, FATCA says, if Bruno claims he's W-8, what evidence do you have that he's really W-8? That he's not a W-9, that he's not really a US national, that he's not really a US resident, that he's not really, and what did we collect from you? Your passport. Why do you need our passport? Well, one, security, but separate from that, we need it because we have to keep it in the file, or now it's all electronic, of course, but we have to map it, attach it to the W-8 so that if we're audited, we can say, see, we had reasonable belief when he said he's not a US national, that he's not a US national because here's a foreign passport. And we don't have to go beyond that standard. That's our standard of knowledge, our standard of care for the withholding purpose, and it alleviates us from that unlimited liability on the withholding. This is of any payers, not just obviously Texas A&M. Okay, that's chapter 4. If chapter 4 is met, we kick into chapter 3. Is there a source in the United States? Oh, there's a source. Now we have to look at, again, withholding and all that. There's not a source, so we don't go to that next step. But let's just say there was the PE. Now I want to get into my theoretical issues I want to bring up that I think are interesting on the case study. Civil versus common law. And this is the Starbucks state aid case. If Holland recognizes under its civil law partnerships as separate entities, by example, then when Starbucks Netherlands operating roaster pays a royalty to United Kingdom limited partnership, it's fair for Holland to say the United Kingdom treaty applies because Starbucks is, from Dutch perspective, we don't care about UK. All we care about is Holland. In Holland, we recognize it. This is country C's argument here. We recognize the limited partnership Starbucks IP management company as a legit company. And so we will assume its residency in the United Kingdom based on our civilian attitude that limited partnerships are real entities, or at least in some circumstances. So we, Holland, don't even make LP have a tax residency certificate, which is a little weird. Now, that's an interesting theoretical discussion about treaties, because I said I start with the whole concept of who has a tax residency certificate, but what if the country doesn't require a tax residency certificate? Then that just blows that one out of the water. The other is, your case study is interesting because it's like it's squid ink. It's saying PPP, PPP, PPP. It's putting PPP in front of you, but that's not the real story, is it? It's the investors, which we brought up. So
Yes.
PPP can't get a tax residency certificate. The investors can get a tax residency certificate. Let's just say there are 100 investors. Are really 100 investors each singularly going to need to get a tax residency certificate that each singularly provides the payor of the capital gain in country C? Now it gets weird at the payor of the capital gain in even country C, because in the payor, let's just say they're in country B, the payor of the gain, they'd be like, I don't care what country C says, we're not subject to their rules, we're in country B. But because the gain is associated with this sale in country C, then you have another theoretical discussion. Regardless, let's say it's in country C to keep it simple. Do all 100 so from my point of view, in the US, technically the answer is all 100, but practically speaking, from an administrative point of view, the payor doesn't want to receive 100 documents. So PPP as a partnership would be the administrative agent for collecting all 100 tax residency certificates and then providing the certification. Again, this would be under FATCA, Chapter 4, to the payor of the capital gains for the sale of the underlying extractive industries company. But correctly, at some point, the payor does need in its file the 100 certificates, because it has 100 different liabilities, because it can't rely on paying PPP because PPP can't get a tax residency certificate. PPP can fill out a W-8. PPP W-8 won't have any backing information if it doesn't supply tax residency certificates or alternative means. It doesn't have to be a tax residency certificate for purposes of FATCA. It can be alternative means, by example, passport, as I originally said. Okay. So tax residency certificate starts the discussion for me, but we've already seen with my little Starbucks example, some countries don't require it. So that discussion may be moot. And that creates confusion perhaps. Bruno brought up the other point that I would make, which is the permanent establishment, which is in the United States, generally speaking, take an LLC, Delaware LLC. Lots of foreigners use Delaware LLCs to do business in foreign countries. Nothing to do with the US, because Delaware LLCs look good. So they may have their two partners for the LLC, maybe BVI companies. And the beneficial owners of the BVI companies may, example, be Russian. I think Delaware has 1.5 million registered companies. Maybe it's more. I forget now the exact figure. It's over 1 million, less than 2 million. And well, not everyone in Delaware has a company, so it's not all Delaware folks, and it's not all U.S. folks. So I forget the again. I have statistics in an article I wrote for the little FATCA book. But let's say about 20 to 25% of Delaware companies are owned by non-U.S. Beneficiaries. So Delaware is the largest offshore jurisdiction in the world from the point of view of selling companies to non-residents. If you took the U.S. as non-resident to Delaware, all the other 49 states, geez, then like 99% of Delaware companies are sold to non-residents. It's a big offshore place. Okay. These LLCs in Delaware, they're transparent, so they don't file a U.S. tax return. But then one of the partners decides to transact some business in the U.S. They open up an office to look good in the U.S. Effectively connected income, what we call ECI, effectively connected income, ECI, that's the U.S. source rule for when business income attaches to United States taxation as a branch, basically. So if there's no treaty protecting you, you have to look at ECI. In ECI, one of the tests of ECI, do you have an office? A shingle on a door. It might be a shared office with 5 other companies, but is it your office? Are you claiming it as an office? So they want to look good. So Delaware LLC has a Delaware address for their office so that if people look them up, it's not a BVI address, because if it's a British Virgin Islands address, they lose the whole purpose of having this look good company. Well, that may make them ECI, which means that they have a branch, or as you were saying, if there was a treaty of permanent establishment in the US. But if they had a permanent establishment rule, it would probably protect them from simply having an office. Probably, not necessarily so. Depends on what happens in that office, right? Are they transacting business? Are the contract communications going through there by email? We don't know. But there's not a treaty protecting them, because from the United States perspective, who is the potential treaty partner relevant to this partnership? It's the British Virgin Islands. It's not Russia. We do have a treaty with Russia, but it's not Russia. They're beneficial owners of BVI companies. So this is BVI, and we don't have a tax treaty with BVI. Consequentially, by opening that office to look good, and they say, oh, it's just a nameplate. Well, one has to look at the case law of the United States, and a nameplate may be ECI. And if it's ECI, they have to file a branch return. So just pointing that out. Okay, anyway, regardless, that's enough for me. Those were some of the issues I think are interesting to point out, but if I had to decide this case, my decision rests with that as I've heard the arguments, because I didn't hear about tax residency certificates being filed, I'm going to go with C. But if you change and you say tax residency certificates have been filed by the institutional investors in A and B, then I'll go with A and B, but there's a lot of procedural mechanisms that have to be worked through to get me there. The filing of the correct, what we would call, again, those W-8s. Are the W-8s compliant, or we call it fit for purpose in English law, fit for purpose for purposes of Chapter 4 FATCA? Oh, are they? Now let's go look at Chapter 3, the source rule. We have source, do they comply with, and so on. Okay, so I'd have to go through those procedural requirements. But if those procedural requirements can be met with tax residency certificates, then I'd be okay with A and B having allocation of income. I'm sorry, having the not the allocation of income, the right to tax the income in the first instance as winner states, and then pursuant to the capital gains article, the loser state wouldn't have any right to tax it.
So
however, last thing would be extractive industry. I mean, because this is an extractive industry company, I have to wonder if the source rules of C don't apply special rules to this situation, but that's not this case study.
So I saw Tatiana smile, but Prof, what happened was when I said residency for the taxpayer is not an issue, we assume that those compliance certificates, residency certificates, it's part of the residency argument. So Tatiana, don't smile anymore.
I appreciate that. Okay, good.
Yeah, I removed the real estate company clause on purpose to avoid the issue of the extractive industries and so on.
I remember from prior lectures, so it used to be the residency certificate, but some countries also require taxes paid. You have to show them corporate income tax return that's been paid, not just residency certificate.
Yeah.
Well, I can imagine a world going forward, although I haven't seen any regulations to this effect from any country, but I'm going to be searching for my FATCA book in the next 2 months. So I started that this morning, as I mentioned, or late last night. So I'm concerned about the economic substance test now. So there's a tax residency certificate. Some countries, you're correct, say, hey, tax residency, did you actually pay any tax? And that would be a tax return. And you don't file your US, if the IRS were to ask for a tax, well, they don't ask for a tax return. No, they do. No, I take it back. There's some situations they do, but they don't really mean a tax return. It's a tax transcript, and it's a transcript of your return, but it's not the return itself. Your return could be 100 pages, or it could be Donald Trump's returns that we've never seen, but are, somebody says are 1,000 pages or something. No, a transcript is a couple pages. It's basically that you pay tax and it has some data on it. So you'd file a tax transcript, not the actual thick return. But regardless of that, there's a potential new third step. And the new third step, I can imagine, again, I haven't seen any regulations, will be a new form. And the new form, or maybe it's going to be, no, it'd have to be a new form. It'll be a new form. And the new form will be the economic substance form. Say your BVI company has economic substance, and BVI will say, oh no, the BVI corporate incorporator or company secretary in British Virgin Islands will say, oh, we'll sign something that we have economic substance. We'll sign anything because we're BVI, that's what we do. But it won't be the BVI test. It'll be the US test, by example, because it's the US that has to decide withholding. So there'll be the US economic substance test. And it's nice that BVI has economic substance regulations. I mean, I know they do. I don't mean regulations in that sense. I know that all the offshore world has set up regulations, because if they hadn't, they would have all been blacklisted by Europe. But I'm talking about the payor, the source country regulations that state when economic substance is or is not. And this is distinct and totally different from limitation of benefits article. Maybe this will be part of the limitation of benefits article in the future. Does the company have economic substance? But I can imagine it being a totally different new form, a new test that is applied regardless of whether you have a treaty or not, because it's not a treaty issue. This is like, do we even recognize the payment? If we don't recognize that there's an entity over there, because it doesn't have economic substance under our new regulations that we just put in place, let's say 3 months ago, we don't have any in the US yet, but if we don't, well, then there's no, the whole question about deduction or not is moot, because we don't recognize the payment. Just like the United States doesn't recognize payments between head office and branch under our domestic law. Forget the treaty situation, but under our domestic law, head office and branches are the same. They can't make payments to each other. They could do it for accounting purposes. They could do it for bookkeeping purposes, but they can't do it for tax purposes. They can loan money to each other for tax, for bookkeeping purposes, but the interest in the loan for tax purposes isn't recognized. So that's our domestic rule. Okay, because they're fiscally transparent, the branch doesn't exist. So there's nothing to consider. So I can imagine a world under this economic substance stuff where countries like the US make regulations with a form attached to it that say, after you've done all your other stuff, or maybe it's even before, do you even have a fiscally cognizant entity to be recognized, so that we can walk through, in our case again, FATCA chapter 4, source chapter 3. So maybe it's going to be the first form that one files, the first test. I don't know. Anyway, we don't have it, so I'm just it's all hypothesis here. Is there any country that y'all aware of that have actually made economic substance rules, not for their internal purposes of are our companies exist, but for external purposes? Does a foreign country's company exist for purposes of being recognized for payment? I'm guessing not. Yeah, I don't think any countries have done it. So I'm going to be searching. And if they have, I'm going to be searching, and I will tell you over the next month as I'm updating FATCA book. But because I plan to have a chapter I'm going to put together that just, again, I think it's going to be a hypothesis chapter right now, but at least I'll be able to say, as of the publication date of December 23rd or whatever, no countries have yet, instituted such regulation. But yeah. Are there any questions about the case study other than what we've covered? If not, then we have two other issues to discuss. One is three actually. Bill Seeger asked me, hey, I'm not a lawyer. I have, do you have anything simple on the company and incorporate? So last night or yesterday, I was just searching through all my old materials, and sure enough, I found. So I'm gonna upload those as suggested reading material. And they describe different types of companies, partnerships, the rights and responsibilities, but they do it in less than 10 pages. And it's actually for my company laws book that I always give second treatment to, but it does exist by Walter Skluer. So it's forced me to look at that, and now I realize I have to update it. But anyway, so I'm going to publish that today into the book. The eCampus, I think my eCampus quota is met, and I can't exceed it in terms of uploading more live videos. So if you're using the eCampus, just use the G Drive, because I have tried like 50 times to upload the videos as live videos into eCampus, and I just keep getting a message that basically says, sorry, your quota is exceeded. I'm trying to upload them as just attachment files, and you could download the file. That's why I'm thinking my quota is exceeded. And I don't know what that quota is, but we met it. And whereas G Drive, I bought my own space, and so I have a, whatever the big thing is, I have it, well, 1T, a trigabyte. Okay, so so Bruno's videos, I uploaded 3, 4, and 5 again to the G Drive, and any new stuff will all be on the G Drive. You may not see it on the eCampus. I think I just exceeded my quota. I think I have to go delete old courses or something to get some space back. Okay, that brings us to Susanna's questions, which I have to open up. She sent an email to everybody in the group, I believe, or maybe it was just Bruno and I, that asked questions about partnerships.
Oh,
On
really?
the
I didn't.
1999 OECD report.
Ah, okay. Yeah. I'm seeing it now.
Okay. Senna says, okay, I just read examples in the application of the OECD model tax convention to partnership attached. Very good comprehensive examples. Some examples, Bruno, you've already covered in your part 3 video.
Yeah, yeah.
Okay, but sometimes the examples are confusing unless to be read several times. So here's an example.
Yeah, the thing is that
Example 16, page 46.
I need to check exactly what, I don't remember the 19 examples by heart.
No. But she's written out the example, so I'm going to state the example, and I'll tell you what I think the answer is. P is a partnership established in state P. Partner B is a resident in state R, while partner A is a resident in state P. So P is a partnership in P, P has a partner in P, and P is a partner in R. State P treats the partnership as a taxable entity. So this would be like your Netherlands. While state R treats it as a transparent entity. So that would be like the United States. P derives royalty income from state R.
Yeah.
It is not attributable to a permanent establishment in state R. So if it was US, it'd be 30% withholding based on source. P has an office in state P that may be considered a permanent establishment in state P. Okay. So I think we did cover this in our discussion, which is in my point, who has a tax residency certificate? So you have a payor. The payor is clearly, I'm just going to use US for my purposes. So R is United States. Royalties being paid from the United States, automatic. I know 30% withholding. There's never a situation in the world that a US payor shouldn't know that. So, so the software catches it. Bingo, lights go off, withhold 30%. Recipient, the payee, says, don't withhold 30%. I'm resident in, and that's where, okay, fill in a W8. Where are you resident? And we go back to my analysis of, do you have a tax residency certificate? Oh, no, you're an individual? Do you have a tax residency certificate? Do you have a passport? By the way, I've never seen somebody apply for a tax residency certificate as an individual in the US.
Right.
I'm guessing it's possible, but I've never seen it. So I don't know that situation per se, but it must be possible. Because how would the partners prove up their tax residence? Well, one partner's in R, so you're a national. You're filling in a W-9 as a US person. So actually there's no withholding, but there's income tax. The partner who's in P if it's an individual, and this doesn't say, this just says they're a partner, it doesn't say what they are. But if they're an individual, they would have to prove that they're tax resident in P, and they would have a tax transcript. But for US purposes, as a payee, or you filled in a W-8, you fill in, you give me a passport.
I already found the partnership report.
You would claim tax residency. You would claim treaty benefit. You'd fill in a treaty benefit form. And to evidence the treaty limitation of benefits was met, you'd have to prove you're a resident there. And residency can't be proved by passport in the foreign country. It just proves that you're not a US person for Chapter 4. So how are you going to get a tax residency certificate? Does Holland issue tax residency certificates to individuals? I never applied for one, so I don't know. South Africa, I was there, but it was too long ago. They wouldn't have, people didn't ask these questions back then, although they should have. Anyway, the answer here is because there is a permanent establishment under the example in the
yes, exactly,
stated in the example.
Yeah, so that's basically it. So since you have a PE, the state of, well, where one of the partners resides, that's a purely domestic situation, so there's no issue on tax treaty application. From the perspective of the other state may tax the percentage of the partner's income on the partnership, but needs to provide release for double taxation. So actually there is no double taxation in the end deriving from this. If he's able to provide the tax residence certificate, which probably here it's relatively easy. We are talking about two partners, one resident in the same state of the partnership, the other one resident in another state. So it should be possible. So here there's no double taxation. I think what Susanna was also mentioning is the fact that when you read the report, sometimes you see there were disagreements among states. Yeah, that's the problem of the partnership report, is because it's based on interpretation of the treaty and not based on specific provisions. So some can say, yeah, I don't agree with that because that's not written there, which is basically what they said. But they say the prevailing opinion is the state B, so where the cross-border, let's call it partner, is resident, it may tax, but then it will provide a credit or an exemption for the underlying PE profits because it treats it as a PE. So it's solved, or it should be solved.
And so this, well, they would never issue a tax residency certificate, but I mean, just in theory, let's just say that country P, because it recognizes he's a resident of R, is taxable entity. Yeah. Let's just say country P issues, if the partnership is fiscally taxable, fiscally resident, fiscally taxable, unlimited liability, worldwide income tax as a corporate entity, basically. So if country P taxes the partnership, then country P should be willing to issue a tax residency certificate on behalf of it. Now, if that occurs and the payor, the royalty is being paid from
here it's the more, I mean,
it's from state R, so it doesn't matter. Yeah, I go back. It doesn't matter. It's a PE. R is going to take its piece of the action, no matter what.
Yes, I mean this is the more, actually. I understand why Susan's had issues. This is one of the most complex examples because it's a royalty, so it's in another state. So supposedly, if you follow the OECD model, you cannot tax. So if you're taxing the company and this partnership is treated as a company itself, you cannot attribute profits to a partner of the company because it's sort of CFC rule. So it may be conflicting. But they say, well, some went for a position, the others for another position. So what I can tell you is that if there is a conflict, a conflicting view, you can have double taxation, but then you go to the map, to a mutual agreement procedure. So, but this is a more tricky issue here. I mean, not always the solutions are consensual, let's say like this. What I gave you in most of the examples was try to give you principles on the application, but like every principle, it has exceptions, and sometimes it doesn't work. That's it, if you don't have a specific treaty provision.
Cool. Okay, we lost Mark. Mark is in Korea. I forgot about that. I know he's at a client meeting in Korea, and it's 1 a.m. in Korea. Oh, it's almost midnight in Singapore, isn't it? Huh. Past your bedtime.
Oh, yes.
And it's therefore it's about 10 o'clock in Indonesia. Okay.
Okay, thank
So,
you.
but
Thank you for the answer. But does beneficial ownership issue is on the examples also?
It depends. So it depends on the nature of the income. If you have passive income such as dividends, interest, and royalties, you can have a beneficial ownership issue. But here, I mean, here in this example, you didn't have different layers. The beneficial ownership issue arises if you have a company and another company or an entity and a partner on top. So different layers in the chain. Here you didn't have that, so it was less relevant. I think.
yeah, but it could, if you had investment funds and you had all these, like, you know, some investors were
Yes.
public companies, some were tax exempt, some were individuals, some, yeah, it just, that's where it gets crazy and it becomes a map process. And because,
I mean,
yeah, as you pointed out, there's conflicting views amongst countries.
it's part of, I think, we will deal, I think, later in the course with the beneficial ownership. At least that would be part of our idea, because it's a really important concept. And there's a lot of ongoing discussion, again, on that. So we can develop a bit more the beneficial ownership issues. Here, there was, in the partnership report, there was not really a major concern.
Well, I think beneficial ownership we should deal with under limitation of benefits article.
Yeah. I think all combined, I agree.
And that's, I think, our last week 12, our like
Probably.
anti-avoidance and all that kind of risk
Yes,
management.
because after talking about limitation on benefits, everyone will run away because it's so complex. So it's better to put it in the last week.
So it's only 26 pages of a treaty article.
It's absolutely horrible.
Okay. So just to conclude that, sometimes the examples are confusing because if you're trying to find a single solution for the example, you won't when two different countries have two different perspectives, especially in the case of one country sees it as fiscally cognizant and the other sees it as fiscally transparent. Well, you're starting off with a conflict no matter what. So, and then you get into all the other juicy issues. So that's the answer to that one. Okay, there's two other issues. The other issues are you have another issue, Susanna? Go ahead.
No, just that. Okay, thank you.
So we got any questions about course admin and next week? So let's start with next week. Go ahead, Odin.
Prof, I have a question about course admin, university admin, that is. For those of us who have not been registered as yet because they still haven't sorted out that location issue to be able to register us. We don't want to find out at the end of the course, we're being told, oh, too bad you've participated, but you're not registered. We can't register you by. So what progress has been made on that issue? Or-
You have to talk to David Dye. I really, everyone thinks I'm the administrator, but I don't even have a dean title anymore. I gave it up. It's just too big of a university. I can't deal with the bureaucracy and get my actual publications and all that done. But the answer is, I don't know.
The issue is for us as students who find ourselves in that situation is Dr. David Dye. He said, oh, well, let me contact this guy at the registrar office that dealing with it, and then you don't hear back anything.
Yeah, you just stay on top of it. I mean, I think the university, well, I don't know about main campus since I'm not there, but I think from our side, they do want to push it because they want to get as many people through the keyhole as possible. Because there is a part A and a part B, meaning course 1 and course 2, at least from my simple perspective, they could drop everybody into course 2. I know internally for students who are enrolled in other programs, because we are doing part A, part B across all the graduate programs online. They're all 6 or 7 week courses. By example, if one of them wants to change, like I just took part A course and now I realize that because I took that, the one I enrolled for part B is not my right, it's not right for me. I should enroll this other course. Well, how do you do that? So they have to change up the enrollment. Well, if that can be done, then it's not the exact same apple to apple, but it's at least it's something can be done within the computer system. There's this issue about when enrollment is counted in audit, because I know that Bill Seeger came in, but under his enrollment, it has this like enrolled after audit period, like big bright letters. I saw it at the registrar's computer screen, and I was like, oh, what's that mean? She said, what it says, enrolled after audit period. I said, okay. So I can't make any promises one way or the other. I can, when I'm on campus, which will next time be, I think, November 1st. No, I think October 31st. November 1st or one of the others, I'll go back into David Dye's office and I send him emails occasionally to remind him, and also Jeff Green. I send emails to Jeff Green to say, hey, can you give me an enrollment count? What's going on? But as I did also mention, the eCampus, I don't think I can upload any more files there. So I wouldn't go there if I were you. I'm not even sure I have authority to delete old courses. I don't think I have administrative privileges to do that, but I probably, well, I don't. I have administrative privileges to delete probably old files or videos within courses that I uploaded. So I'm going to go try and do that for maybe 50 or 60. It's like cleaning out your email. I'm going to go try and clean out old videos and see if that allows me to upload new ones. I don't know. But okay, so the conclusion of that is email David Dye again and Jeff Green, because Jeff is actually admissions. David Dye is the dean over all graduate programs. And he actually knows what he's doing. He came from Oklahoma and he built University of Oklahoma Law School into like 500 online law students. And it's just off the radar screen. That made them the largest program in the US technically. Unheard of. So and they're a public school. So he knows how to deal with like the bureaucracy administration, and he drives the 3 hours each way every couple of weeks to go meet with his colleagues down at main campus. Whereas when I go to main campus, I'm going to see Lorraine Eden, I'm going to see other faculty, I have teaching to do or lecturing or participating in a workshop, and it doesn't leave me much time to go sit in a registrar's office and try and discuss issues, which they look at me and they say, why are we discussing anything with you anyway? you're just faculty. So, I mean, that's literally what happens. If I don't have a title, I don't get seen. So, but in a way, I'm happy. So I'm like, please don't see me. I have work to do. Okay, so I think you
William,
will sort it out eventually.
but with respect to credits, my understanding that last week is their last of week of their first course, right? So if we're not being enrolled next week, so literally there will be no credits for this first part, right?
That's the part we'll have to see if basically it's like backdating. So can they back enroll? I mean, they did it with Bill Seeger, right? So or after the audit period. And you know,
My
is it
issue is
possible? I
following.
know in Part B, it will be possible to switch students around internally because there are always students who want to change courses up, and they can't know what the courses are until they're in that part of the semester. Inevitably, there should be 2 registration periods each semester, but okay.
Okay, I see. So okay. So because my experience is that I'm writing to them, I'm calling them, and it's like talking to the wall, and I have no idea
Oh,
why.
I saw your email. I saw your email because
But
you're
I'm calling
already
them as well.
in the system in theory because you're a student or you're alumni,
Exactly.
recent graduate. Yeah, I don't get that either.
And I'm calling them. I cannot leave my phone number. I was calling from London. They wouldn't call back to London. They wouldn't come back to Singapore. So I don't ask them, but like I just even cannot get through the answering machine.
Well, they can call back. All of our phones work internationally because they're on, we're virtual
Really?
phones.
Because I spoke to David, and David told me that he cannot call back to London. That's why I wouldn't give the Singapore number.
He just didn't set it up then because we're virtual numbers. We're the Text A&M system moved to virtual telephony.
No, he told me to call
When I
back in
arrived,
10 minutes.
he just may not have set it up, but it's possible. The weird
that
thing
was the
about
only
virtual
time when I
telephony is you can't call all numbers, but it's usually Caribbean numbers that don't ring through.
But that was the only time they spoke, and other than that, I'm just literally talking to the wall. Nobody responds to me at all.
Did you contact Bush School though? Like, I know for sure I can't contact them on your behalf because of
Yeah.
FERPA. They won't, it doesn't matter that I'm a faculty member, if you will. I'm not of your unit, Bush. They won't recognize me. They'll deny that you were a student there because they have to do that under federal law. Did you
But who should I
contact them
contact?
though?
Mark, who should I contact? They didn't tell me. I can write to
Well,
Mark
according to the emails, it was Bush had a, well, I'm going to stop the recording because all this is not relevant for the, although everybody was here in class today, but regardless, let me just stop it for a moment. If yes, do you want to receive an email?